Welcome back to another deep dive. We're continuing our journey through the Manual of Patent Examining Procedure, the MPP.
That's right. And today we're diving into Chapter 1800, which is all about the Patent Cooperation Treaty, the PCT.
Yeah, the PCT, that international framework.
Yeah.
And specifically, we're zeroing in on Section 1810. This one's crucial. It covers the filing date requirements.
Absolutely critical. This is like the first gate you have to pass through for an international application, getting that official filing date.
Exactly. What do you absolutely have to do just to get your foot in the international door? So we've looked at various MPP bits and pieces to really break down what Section 1810 demands.
And before we jump in, a quick shout out to Mike Shepard, the creative director behind this whole audio series.
Yes, thanks, Mike. And our usual disclaimer. This summary was put together with AI tools like ChatGPT and NotebookLM. It might have errors, so it's just for educational info.
It's definitely not legal advice. For the real deal, you need the official MPP, a qualified instructor, or, a registered patent practitioner.
Okay, let's get into it. So, Section 1810, PCT Article 11, it's all about getting that international filing date. What's the core idea here?
The core idea is that a receiving office, like the USPTO here in the States, looks at your application the moment it arrives, and it checks if certain minimum conditions are met right then and there.
Minimum conditions. So it's not everything, just the absolute basics.
Exactly, the threshold check. If you meet these minimums at the time of receipt, you get your date. If not, well, things get complicated.
Right. It sounds like you can't just, promise to add something later and still keep that original date, generally speaking.
Generally, no. The date is usually tied to when all those minimum requirements are finally met.
Okay, so let's walk through this minimum requirements checklist. What's first?
First up is applicant eligibility. The application needs to show that at least one applicant has the right to file internationally.
And how is that determined?
It's based on their nationality or their residence. They need to be a national or resident of a PCT Contracting State, one of the countries signed up to the treaty.
Got it. An applicant. That can be more than just the inventor, right?
Oh, yeah. It could be the inventor or maybe joint inventors. Could also be a legal representative or even an assignee, a company, if they have a proper stake in the invention. But someone listed has to meet that nationality or residence rule for that specific receiving office.
Okay, eligibility check. What's next on the list?
Language. The application has to be in a language that the receiving office accepts.
So for the USPTO, that primarily means English.
Primarily English, yes. But the rules are a bit flexible. The sources mention English, French, Spanish as kind of standard prescribed languages internationally.
What if I file at the USPTO, but my application's in, say, German? Do I just not get a filing date?
No, you can still potentially get a date. If the language, like German, is one that the International Bureau, the Central PCT Authority in Geneva, accepts, the USPTO won't process it itself, but it will act under a specific rule, PC2 Rule 19.4.
And what does that rule let them do?
It lets the USPTO accept the application on behalf of the International Bureau and then forward it directly to them.
Ah, okay. So the USPTO acts as a mail drop, essentially.
Kind of, yeah. It gets your application into the system with a filing date based on when the USPTO received it, assuming other minimums are met, but the actual processing starts in Geneva.
Interesting workaround. Okay, so eligibility, language.
Yeah.
What about the actual stuff in the application, the content?
Right, the core elements. You need, first, an explicit statement saying you intend this to be an international application under the PCT.
Can't be ambiguous. You got to say this is a PCT application.
Pretty much. Second, you have to designate at least one contracting state. You need to name at least one country where you're initially seeking protection through the PCT.
Okay, makes sense. What else?
The name of the applicant, which ties back to eligibility. Then, critically, you need a part that is identified as the description of the invention.
The description, okay.
And finally, you need at least one part that appears to be a claim or claims.
Appears to be. So it doesn't have to be perfectly formatted on day one.
Well, that's where it gets interesting. It needs to look like a claim. But this is a huge potential pitfall. What if you forget the claims entirely? Or you submit something that clearly isn't a claim?
Yeah, what happens then? No filing date.
Correct. If the receiving office looks at it and says, there's nothing here that looks like a claim, they won't grant the international filing date immediately.
Uh-oh. So is the application just dead?
Not necessarily dead, but it's in trouble date-wise. The office will notify you about the missing claims and give you a deadline to fix it.
Okay, so I can add the claims later.
You can, but here's the catch. If you add the claims later, Your international filing date will usually be the date the claims were received, not the date you originally sent everything else in.
Ouch. So you lose that original date. That could be a massive problem for priority deadlines and things like that.
It absolutely can be. Losing your original filing date is often a very serious issue. However, there's that nuance we mentioned earlier involving priority claims.
Right. Incorporation by reference.
Yeah.
How does that potentially save you here?
Okay, so let's say the claims you forgot were actually present, word for word, in an earlier application, maybe a provisional you filed, and you properly claimed priority to that earlier application in your PCT filing.
Okay.
And you followed the specific rules for incorporation by reference, which
Yeah.
usually means pointing out what was missing and confirming it's in the priority document.
Then what?
Then you might be able to add those missing claims and keep your original filing date. The idea is the content was effectively there from the start, incorporated by reference from the priority document.
Wow. So making sure you correctly claim priority and understand incorporation by reference isn't just good practice. It could literally save your filing date if you make a mistake, like leaving out claims.
Exactly. It shows how these different rules, filing date rules, priority rules, incorporation rules, are all kind of interconnected.
Definitely a key takeaway.
Yeah.
What's another common stumble? You mentioned eligibility earlier.
Yeah, let's circle back to that. Say you file at the USPTO, but none of the applicants are U.S. nationals or residents. Maybe everyone's German, for example.
What happens then? Does the USPTO just reject it?
They don't reject it outright, usually. But the USPTO isn't considered the competent receiving office for that specific application under the rules because there's no U.S. connection through the applicants.
So what do they do?
Similar to the language issue, if at least one applicant is from any PCT country, like Germany in this example, the USPTO will again act under PCT Rule 19.4.
Forwarding it to the International Bureau.
Exactly. They accept it on behalf of the IB and send it to Geneva. You still get your filing date based on USPTO receipt if other conditions are met, but the USPTO won't be the one processing it initially.
Okay, so understanding who the competent receiving office is matters for where your application actually gets handled first.
Definitely. It impacts which office might act as the international searching authority, for instance.
Good to know. All right, so those are the minimums and some major pitfalls. What about things that aren't strictly needed for the date itself, but are still critical right around that time?
Well, the sources stress getting all the pages of the application submitted on the same day.
Why is that so important?
Because if pages are missing and added later, it could potentially require changing the official date of receipt to that later date when the application was complete.
And like we said, changing that date can mess up your priority claims.
Precisely. That 12-month window for claiming priority is strict. If your filing date gets pushed back because you had to add pages later, you might suddenly find yourself outside that window. So, ensuring completeness on day one protects those priority rights.
Makes sense. Keep it all together. And you mentioned the date could even be the mailing date sometimes.
Yeah, under specific U.S. rules, using things like USPS Priority Mail Express with the right certificate of mailing procedure can lock in the deposit date as the filing date, even if the office is closed. It's a handy tool for hitting deadlines.
Okay. And what about fees? You pay fees for a PCT application, right?
Mm.
Are they needed for the filing date?
Interestingly, no. Paying the fees is not one of the minimum requirements under PCT Article 11 to get the initial filing date.
Really? So you can get the date without paying up front?
Yes, but your application won't last long. If you don't pay the required fees, the transmittal fee, the search fee, the international filing fee within the deadlines set by the PCT rules,
Then what?
then the application will be considered withdrawn. The offices will send you invitations to pay, reminders essentially, but if you miss those payment deadlines, that's usually the end of the road for that application.
So fees aren't needed for day 0, but they're essential for day 1 and beyond.
Couldn't have said it better myself. You need them to keep the process moving.
Okay, so let's try and pull this all together. MPP Section 1810 is really laying down the law for that initial entry into the PCT system.
It absolutely is. It's the rule book for getting that birth certificate, the international filing date, and it all hinges on meeting those minimums right at the start.
Applicant eligibility, accepted language, stating your PCT intent, designating a state, naming the applicant, providing a description, and having something that looks like a claim.
Check, check, check. Get those right, and you avoid early headaches, potentially fatal flaws like losing your filing date or having your application just stall out.
And understanding those nuances, like how the receiving office handles different situations based on nationality or language, or how incorporation by reference can be a lifeline, That's key strategy.
Definitely. It's about being prepared and meeting the requirements correctly the first time, which actually brings up an interesting point.
Oh, what's that?
Well, we said one minimum is providing a description and at least one claim. Does 1810 just care about the presence of words labeled description and claim, or is there an implicit sort of minimum quality needed even for that initial filing date?
That's a good question. Like, if my invention needs a complex sequence listing, and I just put C sequence listing to be filed later in the description, does that count as a description for filing date purposes? Even though other MPP sections have super strict rules about how that listing needs to be formatted with the application.
Exactly. Where's the line? Is the Section 1810 check purely about the existence of these sections, or does the receiving office do a quick check to see if the description actually, describes something minimally, or if the claim actually claims something? How does this initial hurdle interact with later, more detailed requirements about sufficiency of disclosure or claim clarity?
Right. It's that tension between a purely procedural check-the-box exercise for the filing date versus ensuring there's actually enough substance there from the get-go.
It really makes you think about how these different layers of the patent examination process fit together, starting right from day zero.
Definitely food for thought. Another deep dive for another day, perhaps?
There's always more to unpack with the MPP.